have a question which has nothing to do with the trespassing. So like you said, he admitted to stabbing him. Now, he did say after he admitted to doing it to the cops, and the next sentence he said to the cops, "Is he okay?" Can't the defense also bring into it that it was not intentional? He did not.
No, that's a dodge because it's self-serving. He can say, "All right, is he okay?" Doesn't make any difference. You just stabbed him in the chest. Okay, you shoot somebody without justification, and they die from the gunshot, and you come up, "Is he okay?" Well, it's too late now. And the situation
No, no,
supposed.
no. But no. What I'm saying is, by him saying, it's no alleged I did it, and then turn around saying he said self defense, and then he said, "Well, is he okay?" So wouldn't can't the defense say he did not intend to kill him? He did not. His intentions was not to come to the meet
That's not the
and
way the
stab
law
him.
works.
His wait, no, no. I'm asking a question. Isn't the defense going to have to prove that it was not in his intentions were not to kill him?
The intention was to stab. What's the natural consequences of a stab wound?
That doesn't mean kill.
Ah, that's likely. Okay, let's put it this way. Let's suppose that instead of a knife, that he had brought a gun and he shot him in the chest, saying, "I was defending myself."
Saying is self-defense. That's what that would be part of his self-defense.
Yeah,
So
I know, but
that's what I'm saying. His intention. This is the question I'm asking you because the defense is going to use self-defense. Part of that self-defense is saying he did not intend to kill him.
that's not the point. You intend the consequences of your actions. You can't get into a person's mind. You have to look at their actions. Did you stab the person? Did you pull the trigger?
So what is manslaughter?
Manslaughter is the intentional commission of a homicide under provocation sufficient to cause an ordinary person to act in an irrational fashion. So you might have people on the jury who have grown up like me or other people in healthier parts of the country, been in fist fights. And the question is all right, every fist fight you've been in your life that you lost, do you think that entitled you to pull out a knife and stab the person who whipped you in the chest? No, it doesn't. You win some, you lose some. Ain't nobody around won every fight they were in. So are you saying anytime there's a fist fight that if somebody's losing, they get to pull out a knife and kill the person?
Okay, so let me do a little bit of clarity here for the different levels of charges. So break it down first.
First degree murder is premeditation and intention to do something. A homicide. Second degree murder, generally it's in the heat of passion. It's sufficient to cause the defendant, maybe nobody else, to act irrationally. Manslaughter is the commission of a homicide based on provocation that would cause an ordinary and reasonable person to act in that. Then you have reckless homicide. Then you have criminally negligent homicide. Now, the problem is if you are
I don't
smart.
need you to give the definition.
No, I know, but here's the thing. The smart DA would say if you accept the defense proposition, that means that anytime anybody ever won a fist fight, the opponent would be entitled to stab them in the chest with a knife.
So voluntary manslaughter is killing someone in a moment of passion or anger, often in response to provocation.
Yeah, the provocation will be defined with the jury instructions as sufficient.
Involuntary manslaughter, killing someone by accident or through
Yeah, accident. That's also criminally negligent, reckless homicide, whatever. It depends on the state. They
so
various degrees. New York tends to call them murder 1, 2, 3, and 4, and all the way down.
so with Karmelo Anthony, because the defense is going to be used in self-defense, they're probably going to be asking for a manslaughter charge.
That's automatic under circumstances like this. the judge would be on safer ground to charge all lesser included offenses.
Mm-hmm.
And the jury would start with the most serious one. If they acquitted him of that and they moved on, is he guilty of second degree murder? Is he guilty of voluntary manslaughter or involuntary manslaughter? And go on down the list. And they might hang up. They might acquit him of first degree murder and hang up on the lesser included second degree. They might hang up on manslaughter, voluntary or involuntary. I don't like to break it down to voluntary and involuntary because it gets into fine nuances that take a while to charge a jury about.
So it
And
says,
but the point is,
wait,
he
I want to read something real quick.
his mouth off and says, "I did it. I was defending myself." Now, if he claims that he stabbed the guy to defend himself, then defense is going to have to show special justification for using deadly force to escalate a thing that was not involving deadly force.
Mm-hmm.
Now, if he claims to be, I was a 130-pound woman, but he's not, because by the way, the prosecution might try to select people that had been in the Marine Corps, the Army, and then say, do you remember when you dealt with pugil sticks in training in a boot camp? Did they always pick equal sized individuals, or occasionally did they have even girls go up against big guys with the pugil sticks? Because you're getting your butt whipped, this is the most important factor. In any of the fist fights that people used to get into, and sometimes they still get into, if you lose the fight or you're losing it, does that entitle you to stab somebody in the chest because you're getting your butt whipped in a fight? No, it does not. And the question becomes the exact same, because don't think of it as a knife, think of it as use of deadly force. Deadly force is also a pistol, an axe, or a sword. Under the circumstances, does it enable you, if you're losing this fist fight, to pick up a gun and shoot somebody in the dead center of his chest or any other part of his body with a 45
You
or
know what?
9 millimeter because you're getting your butt beat in a
Well,
fist fight?
let me answer that for a second. Let me answer that for a second, because I may say yes under certain circumstances, because you asked the question, even though it could have been rhetorical. But what if it was a woman fighting a man?
That's disparate force, and that recognizes the fact that today's sociology doesn't want to deal with. There are inherent differences between men and women. There is a thing called human sexual dimorphism. Based on the sexuality, there are bone density situations, muscle density situations, various internal organs that are possessed by women, not possessed by men, that make women more delicate than men.
Okay.
There's no way around it.
So here's my, this is the I'm asking you some questions. I'm throwing questions. So so it is definitely a difference between men and women, but there's also a difference between body types between two males. If one is smaller
That
and one
doesn't
is
make
bigger.
any difference, because some of the greatest, the most decorated war hero in American history was Audie Murphy. He was 5 feet 4 inches tall. And the real Audie Murphy wound up being a Western star. He played in various Westerns, 21 of them, and he died in a plane crash.
So
So,
it
yeah,
says, so let me read this real quick. Examples of manslaughter: killing someone while defending yourself or others, killing someone while driving under the influence, killing someone in a car accident due to reckless driving, killing someone by negligently.
negligent, negligent. Damn, you got me so I can't say it.
Sorry, negligence.
Negligence.
Negligently, I don't know. Misidentifying them as an animal. So, I think Carmelo Anthony falls under one of these examples of manslaughter as opposed to murder.
I said manslaughter committed. If you get a full definition rather than that little clumsy abbreviated one. In common law, manslaughter was the taking of a life of another based on provocation. Uh, no, manslaughter is the taking of a life of another in the heat of passion based on provocation sufficient to cause an ordinary and reasonable person to act in an irrational fashion. Okay.
So, right. So manslaughter versus murder. Manslaughter is less culpable than murder because it lacks the intent to kill. The line between manslaughter and murder isn't always clear.
That depends on the state and what the particular charges are. There are 50 states, and then there are the feds. The feds have murder very seldom comes up in a federal court because there's no real federal murder case. Usually, if the murder occurs, it's automatically going to be a state case, unless perhaps it occurs during the commission of something the feds have primary jurisdiction over, like a bank robbery, which also is subject to state jurisdiction.
So it says the U.S. Department of Justice says that voluntary manslaughter can be punished by up to 10 years in prison, while involuntary manslaughter can be punished by up to 6 years in prison.
You know, that's what they do. In some states, like the one I presided over the courts in, it was 3 to 15 years. The presumptive sentence for a first offender person convicted of manslaughter, depending upon the background, is 3 to 6 years. There is a presumption, say in Tennessee, that if someone is a range one standard offender, as we call it, and they're convicted of manslaughter, they're suited for probation or even judicial diversion, where if they complete the probation period, the charges are dismissed and they have no criminal record.
Mhm.
Now, that's what might happen, and that might wind up being a plea bargain. It may not, but the problem is this kid shot his mouth off and said, I was defending myself. In other words, he admitted to the act of stabbing. He may have acted in ignorance or uttered in ignorance when he said that. And there's no real problem with advisement of rights because it was a spontaneous utterance and it was not apparently in response to any question. He just blurted it out. So we will have that in the record. He admits to doing the act that caused the fatality. So was the act accidental? Was it recklessly done without the intention of delivering the blow, or was the blow intentional? That would take it to at least second degree murder. Now, if the second degree murder doesn't lie because of the circumstances and you get more elements of manslaughter, it reduces it. But the problem is the defendant took credit for the act that rendered the situation a fatal situation. He did the thing. He doesn't have to say, I intended to kill him. All that is necessary is that he did an act from which a logical person could reasonably infer that the consequences of that act would be death. You stab somebody in the chest, you're quite likely to kill them. So the issue of intent goes to, did you or did you not intend to stab this guy? And if you say I was defending myself, then a priori you're saying I intended to stab him. Now, that's where it comes in. 130-pound men fighting somebody bigger, whether you're talking about David taking on Goliath or you're talking about somebody like Bruce Lee taking on a big, bulky somebody, even though Bruce Lee's stuff for the most part was fiction, though he did know his stuff. But you see, everybody does not have to be big, and some people are quicker. Now, a quick big man is always going to prevail over a quick little guy, assuming they knew the same thing. But that does not justify the little guy, unless you are at war or that kind of situation, to use deadly force because he's about to get a butt whipping. Just think about it. If that was a justification for using deadly force, How many kids would be dead on the playground in my generation, the generation before, and the generation after me?
But we're not in your generation.
I don't care whether you're in my
You keep
generation.
going
The
backwards.
law,
We're not even talking about my generation. Forward.
the law is the same. It's been the same going on 1,000 years. It doesn't change just because some
Oh,
people
wait.
get
Are you
new
talking
ideas about what they're talking about.
Judge, let me ask you this question. Are you talking about the law or are you talking about kids of your
I'm
generation?
not the kids, forget the kids. We're talking about the law.
All right, let me play this clip of the DA speaking to Fox News.
Okay, let's hear what he's got to say.
Today, the judge dramatically reducing the bond for 17-year-old Karmelo Anthony from $1 million to $250,000 with the condition of house arrest. Fundraising for his defense currently stands above $400,000. My next guest was arguing against any reduction as the prosecutor of the case. It's Collin County, Texas District Attorney Greg Willis. Mr. District Attorney, thank you for being with us here today. Let me talk about your reaction first to the bond being set at $250,000 after the county, the district, asking for $1 million bond.
Well, good to be with you, Will. If I could just say at the outset that before we get into that, there's no greater loss than the loss of a child. I mean, we all know that. And that's what the Metcalf family is living through right now. And our hearts go out to them. And a community like ours, the people expect a serious response to a tragedy like this. And that's what we're trying to do, to deliver justice and to do our job in the right way. As far as the bond reduction goes, it's important for everyone to stay in their lane. And our lane was to argue that the judge should keep it at $1 million. The court decided to reduce it down to $250,000. And as you mentioned, put additional conditions on that, including house arrest and electronic monitoring.
Yeah, he will be on house arrest, as you mentioned, electronic monitoring. You mentioned the community. What is the reaction of the community in Collin County? I spend many of my nights in Collin County. My children play soccer in Collin County. I'm one county over from you, but what's the reaction up there to this entire ordeal?
Well, it's just been devastating. That we are a family-friendly place in Collin County. We have about 1.2 million people, and Frisco is probably the epicenter of parents being involved in their kids' lives and encouraging sports and academics and music and all sorts of extracurricular activities. And so it has really struck a nerve and devastated our entire community.
Mr. District Attorney, I know you can't talk to me about the specifics of the facts in the case, not yet, not until you've gone to a grand jury, not until you've officially filed charges. I would love to ask you, though, about some rumors that might exist out there and what you can confirm or deny. And I'm going to ask you about two things. First, because I'm familiar with the community and I hear a lot of conversation, is it that these two encountered each other for the first time that day at the track meet, or did they have any type of prior relationship, even if it was online, towards before what happened at the track meet?
Yeah, I don't resent you asking that. I would probably ask me too, but I won't be able to address those.
Okay. One more, though, and because I honestly don't know the line of where you can answer questions on evidence or not. So I ask you with curiosity, and we'll find out together, I guess, where that line is and what you can share with me. But obviously at an event with a bunch of kids present, we as Americans, everyone watching, has become very familiar with the idea that kids record things. Is there, to your knowledge, video evidence in this incident?
All I can say on that, Will, is that Frisco PD is collecting all available video, and they are going through all of that right now. And when they submit the case to our office, then we will see if there's any video of the actual act in question here.
Okay, last question. What's your timeline? When do you expect to go to a grand jury? When do you expect to see a case?
Well, the process is this. I mean, Frisco is wrapping up their investigation. And once they finalize that, they will submit it to my office, and my best prosecutors will review the facts and vet those to get it ready for a grand jury presentation. So until we get the case, it's kind of hard to give you a timeline. I would say what's typical in a situation like this, I would say the next few weeks to a month, maybe up to 6 weeks, we would probably get the case by then. And then however long it takes us to review the facts and get it ready for a grand jury presentation is what it would take. So it's not out of question that by the end of June that we could have the case to a grand jury, but that could vary depending on how long it takes Frisco to get the case to us. And
Right.
as eager as we are to review it, we don't want to rush them. We want them to do the professional job that they're known for.
Okay, we'll be watching. District Attorney.
That was a temperate exposition. That was what you would expect from a decent DA.
It takes that long to get in front of a grand jury.
It does. See, figure this out. In certain kinds of homicide cases, you don't have an immediate suspect who's caught red-handed, so to speak, and who says in the heat of passion, he has a spontaneous utterance. He says, I was defending myself. So it might take that amount of time to develop all of the nuances and see what the witnesses have to say. And is there any extraneous evidence from somebody's video camera or whatever's going on? Now, yeah, it takes a while. Memphis, they messed up badly when they had the Tyree Nichols case here. They returned an indictment in the fastest fashion I've seen in 50 years, and they blew it on the charges. They missed out totally on murder in the perpetration of a felony. They charged the defendants with second-degree murder rather than first-degree. So there were some factual allegations that have come to light that basically make a mockery of what was going on, but the new DA had been a law professor, not a criminal trial lawyer or a former prosecutor. So it's not unexpected when you have neophytes in charge of the process. This man sounds like he knows what he's doing. But again, I caution everybody, you are presumed innocent until you're proven guilty beyond a reasonable doubt. Now, at this point, contrary to all of the hullabaloo about the whole thing, there is not any race issue that has interjected itself at this point.
Except for media.
Yeah, well, that's what I was referring to. There's nothing in here to do that. And it's a flashpoint situation. It's not an unusual case. This stuff happens all the time. All the time. I've witnessed this kind of thing myself where somebody felt they were in fear and they were trying to run away and they stabbed our team quarterback with a knife, and he wound up dying 12 hours later. And the question was, when the boy said he was in fear of his life, that didn't work out. So